he's a controversial figure. There's no question about it. He is strident in various opinions that fly in the face of others who are equally, if not more, strident in their counter opinions. Hello, and welcome to the next episode of Beneath the Law. My name's Gavin, here with my partner, friend, Stephen Teal.
Hi, Gavin. How are you doing?
I'm a little trepidatious. Is that a word?
Yes, I think it is a word. I'm going to be a little cerebral today, I think.
Yeah. We'd like to talk about a case today that, I have to say, Stephen, that before we started the episode today, it wasn't without some angst in terms of the case, the subject matter, the topic, the completely profound ability to misunderstand argument, position, and opinion for belief, and the confusion between the two. And that, it really does highlight, I think, the case and the decision and the subject matter highlights a great divide in our society between, viewpoints and the complete intolerance of alternate or different points of view on all sides of the spectrum. I don't know if you've noticed that.
Well, I think it really is a reflection of North American society in particular. I can't speak to Europe because we don't live there, but it's reflective. The decision to me is reflective of where society's headed, and you're either on one side of the fence or you're on the other side, and there's no compromise anymore.
Right, and just so everyone's hanging, what the heck are you guys talking about? In terms of what case? What case are we talking? Well, it could. What case could it possibly be? Maybe we should start a contest for a prize. Pick that case. It's, of course, the decision involving Jordan Peterson versus the College of Psychologists of Ontario, which is a very recent decision from the Divisional Court in Ontario, which was a judicial review application of a decision of a tribunal of the college. And I think that context becomes pretty important in the legal framework that this debate took before the divisional court.
And this is a really good example, Gavin, of why we've named this podcast Underneath the Law.
Beneath.
Beneath.
We're underneath. We're definitely underneath. We're trampled by it.
Well, I might be underneath the ground after this podcast airs, right? So, yes, Beneath the Law. My apologies there. I don't even know the name of our own podcast sometime.
Well, it does roll over you. There's no doubt about it.
Yeah, for sure. But there is a legal justification for the decision of the divisional court. But there is a certainly political or public debate that lies, throughout right now that is being talked about. So there are two layers here, right? There is that public debate in terms of what people see on the surface as to what this decision means. But when you get beneath the law here, there's actually a legal justification for the divisional court's decision.
Yes, that's absolutely true. So, a couple of things that I doubt that there's very many of our listeners that have not heard of Jordan Peterson. He's a controversial figure. There's no question about it. He is strident in various opinions that fly in the face of others who are equally, if not more, strident in their counter opinions. And the clash of opinion is, I don't know necessarily a bad thing to my mind, but it seems to be a bad thing in a lot of people's minds these days that there is such a thing as someone who holds a different opinion. And I would suggest to you that both Dr. Peterson and those who oppose him are probably guilty of that.
in a mean-spirited way, I think, too.
Sometimes.
Well, for sure. I mean, we see that with respect to protests. I mean, protests have a lot of anger in them. You have one side shouting at the top of their lungs, and then the other side is shouting at the top of their lungs, each purporting to act, wrap themselves in the flag of democracy, that they are entitled to free speech and to voice their opinions. And they do it in a very passionate way. And when I read the decision and the commentary that has followed, I think I'm struck by the fact that it's all about not now what is in the eyes of the beholder, but is what is in the ears of the beholder, because it was about tone and not necessarily about what he said, but the manner in which he said it that led to the orders from the College of Psychology.
Right. So let's step back for a minute, because this is something kind of near and dear to my own heart and view of the world. And I've always approached this. Look, I've been involved. I've been a lawyer for over 30 years, as have you. Been involved in lots of cases where, hopefully one more than I lost my fair share of cases. I mean, I know one of our mutual mentors, the late, great Lloyd Holden, said to me, a lawyer doesn't know anything until they've lost their first 100 cases. So it really raises a point that the whole system of justice that we practice in and have made our livelihood in is predicated on a adversarial system, in the sense that there are two sides. They get up, they argue two different points of view. They argue two positions based on the same set of facts and urge the court to come out on one way or the other. It is, by definition, a debate. It is, by definition, a system that is predicated on the notion that there are two particular, viewpoints of any given problem, and that in the debate, the court can distill what is perhaps either the right one or the wrong one, or perhaps, even more importantly, some hybrid of the two that comes to some just result as to the particular issue. So when I see this type of clamp down on alternative points of view and or contrary points of view, it troubles me, and it really doesn't. Frankly, it doesn't matter to me what the point of view is. I always think that everyone is entitled to disagree.
I agree with that, except there are certainly within our prevailing society, and I think any society, in order for it to function, has to have limits on free speech. We see that every day. It's you can't defame somebody, right? If you cause reputational harm by making statements that are false about somebody, there's certainly a cause of action in the civil courts. People that advocate hatred towards either a certain group, whether that's based on cultural identity or religion, that's a crime, and that's punishable. And so society does set up limits with respect to the freedom of free speech. And the courts have said that on a number of occasions. And that's not necessarily, in my viewpoint, incorrect. But what I guess I'm concerned about with respect to Mr. Peterson, or Dr. Peterson's case, is that it really dug down into the tone of his statements. A couple of the issues are certainly very controversial, and I certainly wouldn't necessarily agree with his opinions, I suppose. But to be honest, I really don't listen to Dr. Peterson a heck of a lot, if at all. And but some of the other comments, seem to have been pretty minor.
So let's back this up for a moment, just to give a framework for our listeners, and many of whom are lawyers and probably will not need this, but for those that aren't, this was an application for judicial review of an administrative tribunal decision. And that's an important context from a legal perspective. Judicial review is generally available for tribunal or administrative type decisions of boards or disciplinary bodies of various organizations. And what that is about is it's not an appeal per se. It is a very, very different process in administrative law, whereby a party who is unhappy with a decision of administrative tribunal can bring that decision forward to a court for review by a judge and or panel of judges. In this particular instance, it was a panel of judges of the Divisional Court of Ontario. And that particular framework, however, has very, very strict guidelines for the court and framed within a body of law that is very robust in regards to a term which is thrown around quite a bit in judicial review applications, which is deference to the decision of the original body. And that flows from a basic concept that the courts have adopted up to and including the Supreme Court of Canada, which is to say, look, there are very specialized tribunals, which all they do is deal with one given subject matter or another given subject matter. They know a lot more about that subject matter than the court will, which a court is, of course, a general body. Judges are very, very knowledgeable about a great number of things. But the idea is that courts are jacks of all trades and tribunals are masters of their own. So there is this notion of deference, which means that the court will very, very rarely interfere substantively in a decision of a tribunal. They can interfere for issues such as fairness or bias or something of that nature, which goes to the root of the decision. So in that framework, of course, judicial review applications are, I don't know what the statistics are. You may have a better sense of this than I do. They're rarely successful. They're very difficult. It is a high bar to get over a JR judicial review application. Would you agree with that?
I would agree with that because it's basically very much like an appeal of a decision of a lower court. And we all know that, 80% of appeals get dismissed.
Yeah, I think it's harder, personally. I think it's harder to overturn a administrative tribunal decision, frankly, than a lower court decision. I think the tools in the toolbox may be more limited.
Right, and I agree with that. I mean, it's when you look at it, I think one of the basic concepts that has now come out from the Supreme Court of Canada is that you look at the reasonableness of the decision of the tribunal, and what is the reasonableness of the decision was basically defined by the Supreme Court of Canada in a case called Vavilov as being one that is based on an internally coherent and rational chain of analysis that is justified in relation to the facts and law that constrain the decision maker. And really, that is the crux, I think, of the divisional court decision when they looked at the complaints that had been made to the College of Psychologists about the comments and the statements that Dr. Peterson was making. And I really didn't get a appreciation of this. And I think it's important for the listener to understand what you read in the media does not necessarily reflect all of the facts in a case. And there seems to have been, and you can correct me if I'm wrong here, Gavin, but reading through this case, there was a series of letters that the college had written to Dr. Peterson prior to an actual disciplinary kind of proceeding taking place, whereby the college then made its decision. So there was some escalating correspondence going back and forth before it even reached the stage of a decision being made by the college. And I think that was important in terms of overall context of where the College of Psychologists made their ultimate decision requiring Dr. Peterson to take this coaching.
Yeah, I think that's a very important point. Certainly, there was a series of communication, which, if I can paraphrase it, basically was tone it down both in terms of, I will say, I think both in terms of the manner in which these opinions were expressed, and in terms of the opinions themselves. And then I think also important in that is the actual punishment, if I can call it that was meted out by the college to Dr. Peterson, which, respectfully is pretty low on the totem pole, if I might get in trouble for that reference, pretty low in terms of the variety of discipline that the college could have meted out. Basically, what they required of Dr. Peterson was that he engage in coaching or continuing education in respect of the use of social media and in terms of the manner in which he expressed his opinions. Curious type of punishment, if you will, or result, but that was what they did. And one might ask themselves, well, so what? Professional bodies regularly require members to engage in all sorts of required extra learning and or outside professional development. And so that was nothing particularly onerous, I would have thought. But it was all based upon and faced the arguments from Dr. Peterson that, number one, that all of this infringed his charter-protected right of freedom of speech, and none of his comments, he said, took place in the context of his role as a professional or a qualified psychologist.
Well, and that for me, Gavin, we've entered this podcast assigned to talk about this case. But that's kind of the scary thing for me in terms of, as I understand it, it's only because his podcast contained his biography. And it wasn't that he was professing to give anybody advice, psychological kind of advice or any advice of that nature. It's just that his podcast has his biography. So, here we are as lawyers, and frequently lawyers, get asked to run as candidates in either, provincial elections or federal elections. And you need to speak passionately about certain topics that, touch at the heart of societal values, whether it's the abortion debate or issues related to, we're seeing it now. New Brunswick and Saskatchewan have passed legislation with respect to pronouns and who is supposed to be the decision maker. And we're seeing that now in Ontario, with respect to that the parents should be the ones making decisions on that issue. And you run as a candidate, you certainly put your biography on your website and your brochure, and suddenly everybody knows that you're a lawyer and you're speaking passionately about issues that some people may believe is really offensive. And it's, what I'm struck by overall is that Dr. Peterson was disciplined, and you said it, the college basically told him to tone it down. And it was the tone of the discussion and not really the debate about the issue, which is the lifeblood of democracy.
Yeah, so this to me is the real crux of the conundrum, if you will, in terms of the decision here and the whole matrix of it. Let's be clear. I think that the case stands a pretty clear proposition as follows: it's that Dr. Peterson, I call him Dr. Peterson because I think this is what he is, but he hasn't been practicing as a doctor, so to speak, for a long time. I mean, I think at one point he was a clinical psychologist who saw patients in the course of a clinical practice, and he was very much a practicing psychologist. I mean, I think the reality of this gentleman's life at this point in time is he's, I would say, transcended, but he's moved beyond that in terms of what he does on a day-to-day basis. I don't think he sees patients anymore. He's become a worldwide, he's an
influencer.
He is a social media star around the world. I'm sure he makes an enormous amount of money doing that. Good on him. He's got lots of people who follow him. Lots of people listen to his podcasts, and if that was the purpose of it, he's done very well. Now, obviously, with podcasts of this sort, I mean, being controversial, frankly, is probably helpful. The more controversial you are, sometimes the more people listen to you. So, but he doesn't really practice psychology anymore. So just picking up on your point, but he is very much a licensed clinical psychologist. I mean, he could theoretically practice psychology if he wanted to. He's licensed to do it, or he was, or he isn't currently. I don't know if he's suspended or not. But very much to your point that it's, if you're a lawyer, and we're lawyers, we're licensed to practice law, that's a fact. That is, we are licensed to do something to earn a living doing it, just like a professional engineer or a medical doctor or any other number of, a licensed plumber, you name it. That is your profession, and that's who you are. Picking up on your point, let's say that as a lawyer, licensed to practice law, qualified, went to law school, passed the bar exam, all of those things, I decided to run for a political party that had, some people might call, extreme views. And I was running on the platform of that party. Let's say I ran for, the People's Party of Canada. And I was espousing points of view that obviously a lot of people would find quite offensive. Would my disciplinary body, in our case, the Law Society of Ontario, have the right to discipline us because we express those viewpoints, just because we're lawyers?
Well, but it falls within a spectrum, and this is what the divisional court said was the College of Psychologists were entitled to make a decision with respect to Dr. Peterson's comments, notwithstanding that Dr. Peterson said that those comments were made off duty. And reading the divisional court judgment, there are a number of judgments that have found that regardless that you're, quote, off duty, and to be quite honest, Gavin, I think nowadays it's almost 24/7 in terms of practicing law. You're never off duty, like we're so busy. But what concerns me is, where do you draw the line? And I'm not sure where the line exists, which makes things very, very difficult from a legal analysis point of view, that I couldn't give you any advice, Gavin. And basically I would say, well, you know what? Given the spectrum that a regulatory body can apply, maybe those comments could cross the line, so to speak, wherever that line is, and then you could get into trouble.
I think there's no doubt about it. I mean, I think, and this is one of the things when we started off today talking about our trepidation and angst. I mean, it's a real concern. I think if you're a professional person and you have, is it possible, even as a lawyer, to take what are potentially unpopular views that on behalf of a client or otherwise, and to have that then say, well, you can't say that. You can't espouse that argument. There are many, many examples. And it really is troubling that, to me anyways, that exists. I think the fact is that you can debunk the argument and debunk the position, but I don't know when you take it to the next level to say that you have to then persecute or prosecute the individual who espouses that point of view or what have you. You've taken it to the next level. You're not debunking an argument anymore. You're now debunking the person.
No, but it's look, we hear about chilling effects. Certainly, you and I have been involved in a number of defamation cases and the use of the court system to basically have a chilling effect on the defendant's right of free speech. And so there are, certainly processes in place in British Columbia and Ontario that allow a defendant to dismiss a claim like that, where basically the target or the purpose of the action is to place a restraint on the defendant's freedom to speak freely on issues that may concern a plaintiff. But this is kind of the opposite. Now I have a decision, whether it's the college's decision or the divisional court's decision at the end of the day in terms of the analysis, that seems to have a chilling effect based on your profession. And for some of us, certainly as lawyers, we need to, as you indicated earlier, advocate zealously on behalf of clients. People come to us for advocacy on various issues, whether it's client-related matters or political matters. And now, I've got to tell you, somebody came up to me the other day to talk about the Dundas Street situation, right? And for our listeners, so the city of Toronto has basically decided or is contemplating changing the name of one of the streets that goes through the city, Dundas, because there was some lobbying that Henry Dundas was a slave owner and promoted slavery. And somebody came up to me and said, that's not quite correct. That basically the facts are a little bit different. Henry Dundas appointed John Graves Simcoe. Lord Simcoe was the first slavery abolitionist in North America. And can I talk about that issue?
Can
I take a position?
It's a very interesting question because, of course, this is one of the. It comes back to what we were talking about before. We've kind of grown up in an adversarial system where there's this notion that there are two sides to every argument, and somewhere in between them is the truth, and somewhere in between them is justice. But that's very different, and that comes out of a long history. I don't want to bore everyone with the historical references, but I mean, we all know of the history of orthodoxy, and I use that term not in a religious sense, but just in an accepted. Orthodoxy is defined actually as the generally accepted beliefs of society at a particular time. And certainly throughout, the Middle Ages and such, there was an orthodoxy throughout Europe that, saw various people burned at the stake, for example, for heresy. So, it always reminds me of the, Galileo Galilei, being asked to recant the roundness of the earth and asked to say the world isn't round. And his answer was, but it is, because it is. Well, sorry, I've done not to offend the flat earth people out there. But there is orthodoxy is if you say something that offends a set of beliefs that people hold unchallengeable, the only response to that has to be to repress that contrary point of view. And, the whole notion of small L liberalism and debate came out of what the Enlightenment, which was that we threw off the chains of that particular orthodoxy and that there was now debate and science and review and all of those things. And it troubles me that we're falling back into, on both sides of the spectrum, into this notion that I can't hear a contrary viewpoint that challenges my view because otherwise my view cannot stand up to that challenge. Rather than confronting the challenge head on, is really to douse it or to quiet it or to say, you can't say that, just like Galileo.
Sure, but that, Gavin, in my view, strikes at the heart of democracy. Right? Anybody who has taken a political science 101 course will understand that democracy advances because you have people on competing sides of an issue being able to freely speak about those issues and have an opinion on those issues. And the way that society advances is through that debate to come up with a conclusion or a decision as to which side of the debate should carry the day. And that's what social movements are all about. If you look at Black Lives Matter or defunding the police, those are social movements which, frankly, if you're a police supporter, you would find heresy in those comments to defund the police. But that you have the debate about defunding the police causes thought on the other side of the fence to say, okay, you know what, maybe we should modify our policing tactics.
Exactly.
Right, rather than suppressing the view.
Exactly, because the contrary point of view allows for improvement on all sides of the equation. And, sometimes, and I think on both sides of that, there would be a heresy if your belief system is such that cannot accept a contrary point of view and or improve or evolve your thinking based on another perspective. But, one of the topics, just sort of, I don't mean to be delving back into historical analysis here, but one of the I would have thought less controversial comments of Dr. Peterson that was highlighted in one of the complaint letters was he's got some notion about there was some debate about overpopulation on the planet, and his Dr. Peterson's I think his view, and maybe I'm misstating it. If I am, I apologize. But that overpopulation of the planet is a problem. That there are maybe too many people around.
He probably stole that from one of the Da Vinci Code movies that I was actually watching the other night.
But his comment, I think, his comment is satire. I thought it was satire. He talked about, they're just poor children anyway, so who cares? And I thought it was satirical in the sense that, very much reminded me, frankly, the comment of Jonathan Swift, who, of course, was a satirist of the first order and led to great political change in Britain at the time. And his comment, and he wrote something called A Modest Proposal, where he suggested at the time, because children were starving in Ireland, or people were starving in Ireland, that the solution was pretty simple. Just have the Irish eat their children and everything will be fine, because they're producing too many of them, and if they're hungry, that's what they should do. And it was obviously outrageous and ridiculous and satirical, but what it did is it held up to light the equally oppressive and absurd position on the other side through satire. And is Dr. Peterson now not allowed to be satirical? Would Jonathan Swift, if he were a practicing psychologist, lose his license in 2023 if he made the comments he made in A Modest Proposal?
I don't know. Again, I can't tell you because I don't know where the line is.
Well, that's, I think fundamentally, I don't know where the line is critical. And it seems that professional regulatory organizations get to draw that line wherever the particular body or wherever the particular view at the time decides it may be. I mean, what the court said in the Peterson case was, quote, like the legal profession, the health profession recognizes limitations on free expression to, quote, maintain, quote, boundaries of civility and professionalism. So I guess my question to you is boundaries of civility. Who decides what those boundaries are?
The decision maker.
Well, I guess the question is
right?
Who decides? Who's the decision maker?
Well, and exactly. And who gets appointed to be a decision maker by a self-regulatory body? And, we've had this debate, Gavin, within our own law society on statements of principles that we were all asked to adopt. A number of members of the profession fought against that to basically repeal that statement of principles. But it led to a great debate within our own profession as to how far should our regulatory bodies go to basically tell us how to think or how to act.
Well, it's not just to tell us how to think or act, but to require, in the case of the statement of principles, just in case our listeners aren't familiar with that, it was actually a requirement that you file a signed statement that said you agree to it. It is
an oath, so to speak,
a profession of faith.
Right.
So that that I think inspired the backlash within the profession on that. And let me say this: I don't think, for the most part, there may be some people who didn't agree with it, but they were statements of principles that I think most people would agree with and not have a particular
issue with,
particular problem with. Voluntarily saying, yeah, that makes perfect sense, and I try to live my life like that, or I try to practice law like that. I think the question was the compulsion issue, which was the notion that, you need to stand up and swear to this in front of everyone, or else you cannot make a living.
No.
That's the problem.
And certainly, Gavin, just to kind of take this beyond the decision, I find that there's a much greater backlash today than there was, when you and I were growing up, of being told what to do. Right? You were told what to do, but you kind of followed those rules because that was the accepted societal norm at the time. But I really find now that other people telling somebody what to do is leading to this backlash, and it's the debate. And when you look at it, Dr. Peterson, Donald Trump in particular, are representative of a counterculture they're being told now what to do by the people who didn't like being told what to do.
Yeah, there is an irony to this, that the views that are being expressed as the new, I'll get trouble for this, the new orthodoxy are exactly those who, 50 to 60 years ago were on the other side of the then orthodoxy and were outcasts and castigated for their points of view. Tolerance was not something that was known for those particular groups in that time. And tolerance, I expect, by those particular, is not being shown now on the other side. I don't know that you can tolerate, views that are objectionable or abhorrent or espouse violence or espouse hatred. No one can really tolerate that.
Well, we shouldn't tolerate those points of views, but you made the point about satire. If I said, in response to a politician who takes a position that I don't believe in, and I express it as "really," would I be in trouble for that?
Yeah, it's remarkable what you can not say or what you cannot even allow to be said. And I mean, it is troubling in a lot of ways, because how can you have, and going back to our point, how can you have a debate on any issue unless both sides of the argument are allowed to be heard? And let me say this. How would you ever know that one side of an argument is completely nonsense unless you were able to hear it? I mean, the one thing about ridiculous points of view is they're exposed when they're made.
Right, exactly.
And I think you're right. I think that people like Donald Trump, creatures like Donald Trump, and I call him creatures because he's a phenomenon. Because he's a phenomenon of those who feel they are now disaffected, disempowered, that their place in society has been lost, and they feel that he's their voice. And that's all as a result of, this sort of viewpoint that he has capitalized on, frankly, and I think quite cynically, by saying that you are the disempowered, disenfranchised, and I am now your voice, and we're going to come back, and that type of sentiment. And I think, people who scratch their head and can't figure out why he gets popularity every time a new indictment falls down on him need to think about that. That's exactly why, because what that does is it proves to his following, see, they're out to get me, which means they're out to get you.
Right.
The Peterson case, as I understand it, there's a promise of an appeal, further appeal, or seeking an appeal. What do you think the chances are there?
I think he needs leave to appeal. First of all, I'm not sure from the route, but regardless of what route, I don't see a appeal being successful, because it's based on the principles of administrative law, and that's the legal justification that the divisional court really can rest against. It has nothing to do overall with the content of the college's decision. It's the process, and was it a reasonable decision within the analysis of administrative law? So unless you change the principles of administrative law again, I really don't see an appeal being successful. But on the same token, is that really important to Dr. Peterson? And does he really want to use the appeal as a platform to further the debate on this issue? And, just getting back to one of your earlier comments, you think about, particularly in the United States allows the Ku Klux Klan to march, and they march. And it exposes the weakness of their position and what they're trying to promote. And that helps society advance.
I agree with that. I mean, just to leave that point, I mean, I think an appeal will, I don't know if leave will be granted, but just quoting from the Supreme Court of Canada, and this is really, I think, what your point is in a nutshell. What the Supreme Court said in Vaviloff, right, was that the role of the courts in these circumstances is to review, and they are, at least as a general rule, to refrain from deciding the issues themselves. In other words, the role of the court in a judicial review application is very, very limited, very constrained. But I will say that I can see, being the contrarian that I am, just like Donald Trump, I can see why there might be benefit to losing that appeal to further gain traction on this alienation type isolation view that has propelled people like Donald Trump and et cetera to extreme popularity among certain segment of the population. It can be used to say, look, you see, you can't even say this anymore. The courts will back them up. They're trying to shut you down. They're trying to shut me down, which means trying to shut us down. And I think that's a problem.
And it gets all back to the certainly the books that I read in high school. Here we are in 1984, Brave New World.
Well, yeah, it's what,
you're right.
40 years too late.
You're being watched, and everything that you say or think will be surgically parsed to determine whether you've crossed the line. And by the way, I should say this: I do not promote the KKK. In fact, I'd be well on the other side of the fence with respect to that, and the values that they promote. Those are not the values that I promote.
No, but I think that it comes back to I think it might have been that case. What rings in my mind is, and I can't remember what U.S. Supreme Court justice said it, but there was a statement about, when talking about freedom of speech, that it's not important for the things you love. It's important for the things you hate. Freedom of speech for people to sit around and say a bunch of stuff that everybody agrees with isn't much of a freedom at all. Freedom of speech only really matters when you can say things that people don't agree with. Otherwise, what do I need a right for?
We can probably leave it at that, and it's a really great question for our listeners to contemplate.
Yeah. So once again, thank you very much for joining us for what is probably a fairly controversial episode of Beneath the Law. Very interested in your feedback, especially if you don't agree with us, especially if you've got a contrary point of view. Always interested to hear that, always interested to learn from it, always interested to try to spin the argument around and look at it from a different perspective, because that's how law is made. That's how arguments are crafted. And understanding the other side of the argument is, in my view, the secret to good advocacy in any particular, be it courtroom argument or otherwise, and societal debate. And looking at the world from the perspective of another is always an interesting way to go about it. So please send us your comments, criticisms, kudos, if you have them. And please give us a rating if you can on your favorite podcast supplier. And thank you once again for tuning in and listening. Really appreciate it. Stephen, until next time, always remember that if no one is above the law, everyone is beneath it.